All right, we're here for another Ask the Expert, this time on Native American politics. So we have with us today Dr. Tessa Provins, who's an assistant professor of political science at the University of Pittsburgh. And Dr. Provins is also a member of the Choctaw Nation and has research investigating the differing legislative structures of Native American tribal councils and their effect on intratribal, intertribal, and government relations and policy outcomes. Welcome, Dr. Provins.
Hi, thank you, Dr. Cusson, for the kind introduction and the invitation. I'm happy to be here.
Great. So this is a topic where I think a lot of some students at OU know a lot, and some don't. So we're going to cover some basics, and then we'll get into some specifics about a recent Supreme Court case. So the first question is, could you briefly describe the relationship between tribal nations and state and federal governments?
Absolutely. So I'm going to talk about the relationship between the different levels of government, federal and state, and tribal nations separately, since there's pretty significant differences between those relationships. So for the federal government, just as sort of a quick synopsis, there are 574 federally recognized Native American and Alaskan Native tribes and villages. Now, there are also 6 tribes that are petitioning for federal acknowledgement and 5 tribes that are requesting federal acknowledgement. And we'll get to this in just a second about what those 2 different things mean. Now, excuse me, these 5 tribes are basically going to become petitioners as soon as they supplement their petitions with additional materials and declare those submissions complete. Now, before I explain what federal recognition is and how does that impact tribes with regard to becoming federally recognized and what that means, I want to mention how long federal recognition can take. So there are 3 tribes on the list that have been petitioning for federal recognition since 1994. That's over 25 years. And the regulations for recognition were developed in the early 1970s. And the last time these guidelines were changed was around 1994. But it can take an incredibly long time for tribes to get federally recognized. So how does a tribe become federally recognized? Well, the first is tribes can send a letter of intent to petition. And remember those 5 tribes that I said were requesting acknowledgement? This is the stage they are in the process. So after the letter of intent is filed, tribes have an unlimited amount of time to prepare and submit their petition with evidence showing that tribes meet these requirements for acknowledgement. Now, once that's submitted and received, the tribe is considered a petitioner. Now, you might be asking, what evidence is needed for federal recognition then? That's a great question to jump to. So this includes things that are current items like who's the current tribal leadership, their location, the number of current living members that they have, etc. And there's also historical evidence that's needed, including historical location and ancestry. Now, this can oftentimes be difficult because tribes don't have extensive records in some cases, and particularly extensive written records. Now, there are mechanisms for oral histories to be used in these petitions, and I definitely want you to know that. Now, what are the criteria do you meet? You've submitted your letter, you've submitted your evidence. Now, what is that going to be judged against? That criteria is that tribes have to have distinct communities. We can think of this as social and cultural. The tribe has to have political influence and authority. That means they have a distinct governing structure. The tribe must have governing documents. You can think of this as the Constitution, although it can take form in many different ways that we might not think of for tribal nations. Their ancestry, and that it's not composed of members of other federally recognized tribes. That means that tribes' membership is distinct from others, and that Congress has not previously prohibited or terminated the federal relationship with that tribe before. Now, there's other ways to be recognized outside of this process. Congress can recognize tribes through legislation, the president can recognize tribes through executive orders, and the federal courts can recognize tribes through litigation. Now, what does federal recognition actually mean for a tribe then, now that we've talked about how they get federal recognition? In its most basic form, it means that the US government recognizes their sovereignty. That is, that there's a government to government relationship with the US, and tribes have the right to self-govern. They have the right and authority to regulate their activities on their lands independently from state or federal government control. Now, there are sometimes sovereign powers relinquished under treaties with the US, and those that Congress have expressly extinguished as well, and those that the federal courts have ruled are subject to existing federal law or inconsistent with overriding national policies. I'm not going to bore you with what all of those are at this exact moment. But just noting that those are exceptions. So tribes, therefore, possess the right to form their own governments, make and enforce laws, both civil and criminal, to tax their citizens, to establish and determine membership, for example, tribal citizenship, to license and regulate activities within their jurisdiction, to zone their land, and to exclude persons from tribal lands. Now, understanding the limitations on inherent tribal powers of governance are few, but do take these limitations as applicable to some states. So neither tribes nor states have the power to make war, engage in foreign relations, or print or issue currency. And so those are some of the things that still hold. Now, federal recognition also makes tribes eligible for funding and services in reservation lands. Not all tribes are granted reservation lands when they are granted federal recognition, and the size of reservation lands vary pretty substantially. So there's about 56 million acres held in trust by the United States for various Indian tribes and individuals that make up about 326 unique Indian land areas. Now, the largest of this is 16 million acres for the Navajo Nation, and the smallest of this is 1.3 acre parcel in California. Now, many of the smaller reservations are less than about 1,000 acres. Now, what is a reservation exactly? It's Indian reservation is a land area reserved for tribes or tribes under a treaty or other agreement with the US executive order, federal statute, or administrative action as permanent tribal homelands. And this is where the federal government holds title to land and trust on behalf of tribes. Now, there are 63, Now I want to move over to states. And just to note, there are 63 state recognized tribes as of our conversation today. Now you might be thinking, what's the difference? And that's a totally legitimate question. I'm going to describe to you what those differences are. Now, state recognized Indian tribes are not federally recognized. However, federally recognized tribes may also be state recognized. So this acknowledges their status within the state, but it doesn't guarantee them funding from the state or federal government. Now, I'm talking about states in this case that have created formal processes for tribes to be recognized. These include states like Alabama, Connecticut, Delaware, Georgia, Louisiana, Maryland, Massachusetts, New Jersey, New York, North Carolina, South Carolina, Vermont, and Virginia, just to name them very quickly. Now, there's about 20 other states that have started these formal process to start these formal processes or making these formal processes, but they haven't finished that yet. So the state recognition process differs by state. We're not going to get into each of these individual states that I've listed out, don't worry, for the sake of time. The relationship between individual states and tribes is different because tribes have sovereignty. Now, states have no authority over tribal governments unless they expressly are authorized by Congress. And federal recognized tribes are not subordinate to states. I do want to note that tribes frequently collaborate and cooperate with states through compacts and other agreements, matters of mutual concern, such as things like the environment or law enforcement, though. So, in some cases, state recognition qualifies tribes for federal and state support. Remember, I just mentioned it doesn't guarantee them that. The process of recognition in states usually happens through the state legislature, but there's other places like North Carolina, where the Commission on Indian Affairs provides education, technical assistance to tribes, and a state statute authorizes this commission to recognize tribes. and defines the procedures for doing so. So, right, the state legislature in some states, and then this commission in North Carolina is an example of another way that this might happen. Now, there are a few other things that differ in state relationships. So some states authorize tribal participation on state commissions. That typically happens because these commissions are making policy decisions that affect American Indians. And states' tribal recognition specifically can interact with these types of commissions and policymaking bodies.
All right, we had a brief little visitor there. She might come back. Just sort of big picture, it strikes me that we can think about at least federally recognized tribes as they're sovereign and that they can negotiate with different levels of government on some things, but not on others. Not quite like a different country within the US, but in some ways, yes. Is that sort of big picture? Is that?
Big picture, you can think of it as sort of a sovereign nation, yes, within the US that the government has to interact with as another government body. And like I mentioned, there's some exemptions, but that's basically the interaction with sovereignty, is that they have their own governmental structures, they make their own rules, their own laws.
Okay. So real quickly, you hinted at this a little bit in your discussion, but how is this relationship, and probably thinking more about between the federal government and tribes, how's that changed over time?
This is my answer will solely look at the federal government and tribes relationship for this. So just to be really clear, early in US history, the federal government sought to limit tribes' sovereign powers. And this practice became pretty embedded in federal law. And by 1832, when the United States Supreme Court case happened in its Worcester versus Georgia, the Chief Justice at the time, John Marshall, issued a pretty famous decision about this. And the decision said that Indian tribes were domestic dependent nations. And what that meant was that they were no longer independent nations posing absolute sovereignty. So this gets to the question that you were just asking before. And so with this decision, the government reserved the right to control external and diplomatic relationships with tribes. What this basically was the reason is that they didn't want tribes to have intergovernmental relationships with other countries. And so this did limit the sovereignty of some nations, but it did give tribes this larger measure of sovereignty, allowing tribal governments to exist and regulate their own affairs. Now, this has changed a bit over time, and there's another aspect of this, which is self-determination. Now, the US government used to control the policy and funding surrounding tribes, and it dictated if, when, and how federal programs would be implemented on for tribes and tribal lands. Now, over time, Congress has recognized the right of tribes to have greater say over their development, the implementation of federal programs that are impacting them and their tribal members on the day-to-day basis. So by enacting a couple of major pieces of legislation, they were able to embody some of these important concepts of self-determination and self-governance. Now, through these laws, Congress gave tribal governments the authority to administer themselves the programs and services usually administered by the BIA. That's the Bureau of Indian Affairs, but more commonly known as the BIA, for their federal tribal members. Now, this has been upheld, and the principle of tribal consultation comes in, and this is where the federal government can consult with tribes on federal actions, policies, rules, and regulations that will directly affect them. And that's another important part of self-determination.
Okay, and so this, well, I guess the era of self-determination that largely started in the 70s, right, with President Nixon, and then sort of grew from there, right?
Right.
Okay, so depending how you want to think of things, relatively recent, or far in the past, depending on how old you are.
Yep. We'll go with relatively recent still, sure, by all measures.
Yeah. I should just sort of as an aside, put a plug in for the Carl Albert Center. We have a lot of archival materials related to this era So Carl Albert was speaker during when some of this legislation was moving, and majority leader a little bit too. So if you're interested in this era and want to study it historically, you might come and look at some of our archival documents like some people have. Okay, so let's change tracks just a tiny bit. So we talked about in the prior question relationships between the federal government, state governments, and tribes, but you said tribes have their own governments. So could you give maybe one or two examples of how tribal governments work? And I should preface this with probably they're all a little different, right? So we can't cover all of them. That would be a course on Native American politics. So just like state governments are all different, tribal governments are all different. So maybe just a couple examples.
Absolutely. So this is such an important question, and it really closely relates to the research that I'm actually doing. So so many tribes have governance structures, and with 574 federally recognized tribes, you're absolutely right. They can look very different. This can sometimes be affected by the size and scope of tribes. We can imagine that governance might look very different for a very small tribe versus a very large tribe that's spread out geographically. Now, so many tribes have governance structures that look like the US. So that means that they have constitutions that have an executive branch, oftentimes called a chief or a president, a legislative branch that's oftentimes called a council or a tribal council, and a court system. Now, I'm probably going to talk about the courts in a few minutes, but there's something really important about tribal court systems, and I want to make a note of that. Generally, tribal courts have civil jurisdiction over Indians and not Indians who are residing or do business on federal Indian reservations. And tribal courts also have criminal jurisdiction over violations of tribal laws committed by tribal members residing or doing business on reservations. Now, like there are some tribes that have tribal government structures that look like or mirror the US in some ways, there are also tribes that have different types of systems, and that's where their constitution doesn't separate the branches of government the way that we just talked about. And this structure oftentimes takes the form of a tribal council that's led by a tribal chair. And this type of council is one body, and they handle all of the executive, legislative, and judicial decision makings for that tribe. Now, when we look at these differences, we can also think about how tribes will, in their government structures, not only make these different decisions based on how their government structure is set up, but also how they run elections. So just as a note for some of the research that I'm doing, I'm currently looking at how they hold elections for government offices within tribes. And this varies pretty widely. So they have different rules on who can vote and the actual election process itself. And I will get back to you at some point about what, and hopefully have some really interesting articles out about what this looks like and how it differs across tribes.
All right. I'll ask a little follow-up. So could you give maybe some examples on differences on who is allowed to vote? So maybe some tribes, maybe you have to live in a geographic boundary. Some you might just have to be a member. Is that right?
Right. So this is part of the data that I'm trying to collect. Thinking about tribal membership, just to be really clear, most tribes measure tribal membership based on blood quantum. And so in some cases, some tribal nations recognize somebody as having membership that have blood quantums that are like 1/4, right? So 25% of your blood quantum. Or 25%. Others recognize up to a 64th for tribal membership. So I believe the Choctaw Nation is 1/64th. So those blood quantums might be used for tribal membership, which can impact voting rights. And whether in certain voting rights may be for exclusively members that live on reservations and others that are not. Others may allow for individuals that don't live on reservations.
All right. So you've alluded to the McGirt case. So my background here lays out some of the geographic area that was part of the case. So that was a case that took place in Oklahoma. Actually, a fair amount of the background research was done on campus, so mostly in the Western History collection, but maybe a little bit in the Carl Albert collection as well. So you could just give us some details about this case. Sort of it got a lot of media attention. So maybe some details, and what does this mean for the people in Oklahoma who live in the covered area? So actually, I look in this map, I'm very close, but not in the covered area. The purple, the top boundary is the Canadian River. I can almost see it from my house, but not quite. But there are a lot of people who live in sort of the covered area, so to speak. So just could you tell us a little bit about the case and how it matters for the state?
Yeah, absolutely. So let's break this down just real quick. What was the actual case about? The petitioner, Mr. McGirt, was a member of a tribal nation, the Creek Nation in Oklahoma, and was convicted by Oklahoma State Court for 3 serious sexual offenses that were committed within the historical Creek Nation boundary. What you're seeing on Dr. Crespin's screen in the back in the green. And so his argument was that Oklahoma didn't have the right to exercise jurisdiction over him because under the Indian Major Crimes Act, any crime involving a Native American victim or perpetrator or occurring within recognized reservation boundaries, that green area that you're seeing, is subject to federal jurisdiction, not state jurisdiction. So remember, he was convicted in state court. Now, this was appealed up to the Supreme Court, and the decision on July 9th held that under the Indian Major Crimes Act, lands reserved for the Creek Nation in eastern Oklahoma constituted Indian country. As a result, the state of Oklahoma couldn't legally try a Creek citizen for criminal conduct in state court. Now, the second part of this is, now that we know what it was about, why it got appealed up to the Supreme Court, and what the decision was, what does it mean? So the decision puts into doubt on its face, right, other state convictions of Native Americans and could change the handling of prosecutions in the state. But there are other aspects of this case that are so important. And first of all, it's really significant for tribal nations after what are considered to be a lot of egregious actions by the US government, including breaking treaties and attempting to legislate and assimilate tribes out of existence for a number of years, that this court case upheld tribal sovereignty. So specifically for the Creek Nation, this ruling confirmed that this was their land, and that the decision was in fact upholding tribal sovereignty, which we've talked about now, tribal obligations with the US government, and tribal land boundaries. Now, some have also noted that some of the implications of this could have be farther reaching and impacting things like zoning, taxing, other government functions, but this is going to have to play out between Oklahoma, the federal government, and the 5 tribes of Oklahoma, and certainly not something that I want to make speculations about. But I just want to note that there could be other implications from this decision.
That's pretty normal for a Supreme Court decision, right? So, as we'll talk about in the Supreme Court section, or judicial politics section, right? There's no guilt or innocence in this case. It was merely a question of who has jurisdiction over the case. So yeah, there's going to be lots of questions moving forward, and the state government will have to work that out. Sounds like we're about ready to go here. So yeah, thanks for having us. Thanks for teaching us a little bit about Native American politics. For me, I'm pretty new to this. As I said at the beginning, I know a number of students know a lot about it, and others it's new to them. So I think it's an important topic to cover within American federal government, because it is an important part of how governments interact with each other. So thanks for joining us, and we appreciate all your input.
Absolutely. Thanks for having me. And one other thing that I'd like to mention is obviously the Carl Albert Center is this wonderful resource where there's tons of archival research that can be done. There are other places if you're interested in getting more information about this, including the Bureau of Indian Affairs website and individual nation websites. And so you can go to the Choctaw Nation website and learn more about their individual government structure or some of the programs that they have if you're interested in diving a little bit deeper into certain tribal nations. And this can be really important for giving you some more specifics other than some of the general things that I've talked about today. Thanks for having me.
All right, thanks.